Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the editorial dictation without any stop. The Kerala High Court on Wednesday laid down that a person who did not sign a compromise which led to passing of a compromise decree but subsequently acted upon the same could not thereafter avoid the decree merely on the ground that she had not put her signature on it. In law, nobody is allowed to approbate and reprobate. To put it differently, a person who enjoys the benefit of a compromise he did not sign after filing an affidavit acting upon the same and obtained the money in terms of the compromise cannot deviate from the said compromise on the ground that he or she did not sign the same after acting upon the same. The plaintiff had instituted the suit for fixation of boundary, recovery of possession, and consequential injunction. During the pendency of the suit, a compromise was entered into on the basis of which a compromise decree was passed. The first defendant, who is the appellant, herein assailed the compromise on the ground that the party had not signed the compromise and was accordingly not bound by the same. The plaintiff, however, countered the argument, averring that although the first defendant had not directly put the signature, the latter had still acted upon and received benefit from the same. The court noted that the signatories to the compromise included the plaintiff and her counsel, the fifth defendant who expired subsequently, and the counsel for the whole defendants. At the very outset, relying upon the decision in Prashant Kumar Sahu vs. Sahu 2023, the court observed that the law was well settled that where a compromise had not been signed by a party but by the concerned lawyer alone without any express authority or without special wakalatnama executed in favor of the advocate to sign in the compromise signed by the advocate for and on behalf of his client would be unlawful. It, however, added that the legality of the compromise would have to be addressed by scanning the consent of the party from the attending circumstances, including the subsequent conduct of the party. The court at this juncture was posed with the question as to whether challenge against a compromise decree would be permissible by way of an appeal and the grounds for the same. It observed that as per Order 3 Rule 1A 2, in an appeal against a decree passed in a suit after recording a compromise or refusing to record a compromise, it shall be open to the appellant to contest the decree on the ground that the compromise should or should not have been recorded, while Section 96 within bracket 3 of the CPC provides that no appeal shall lie from a decree passed by the court with the consent of parties.